today morning. I'm not sure if you all are aware, in Maharashtra, during Ganesha festivals, there are lots of pandals that are put. And there is this famous Lal Bagh Charaja. Then you have another, multiple 2-3 names. And what I was reading is that every pandal, every kind of a Ganesha statue has got copyright for the faces. So basically, nobody can copy the particular. So, for example, if it's Lal Bagh Raja particular sculpture, no one can copy that particular face in any other statue. So those manufacturers who are those sculptures, whoever makes that particular statue can only make those faces. No one else can copy it. They have got a copyright for making those kind of statues, those kind of faces only. So that's why you don't see any other face which is similar to those kind of statues. So that's one example of copyright. So they have taken a copyright on the face, especially the face, not the whole body structure, but the face of how the Ganesha idol looks. They've taken a copyright. And I was reading the article today morning. Okay, coming up to the next topic is law of designs. Now, the law of designs, law relating to designs is also a particular in intellectual property rights. Now, what is a design? A design can be a shape, a configuration, a pattern, ornamental composition. It can be lines. It can be color. So basically, any figure, any item, any 2D image, any 2-dimensional or 3-dimensional image, it can have color, it can have black and white, it can be anything. If that design is designed, now you can apply for a design intellectual property right. Now this is not a trademark. Now trademark is something that you publish it, but this particular thing you do not publish it. It is for your internal use. For example, say if you're applying for a patent, now you're applying for the end product. Say if you want to apply for the design of the plan, or say for example if you want to you have a particular machine that you have manufactured, and that whole entire plan on how you made that machine. Now that particular step by step can also be patented. Now say you have constructed a particular statue, or you have constructed a particular government building. Now that can also be the design, the plan, that can also be applied for an intellectual property right. So patent is something, the end product in you can apply for intellectual property right. Design is a step way it is constructed. So that's called a design. Now the proprietor of a new or original design can apply for the design. Now where the author of the design for good consideration executes the work for some other person, means the person for whom the design is to be executed. Now so basically a person is a proprietor or author of a design is someone who makes it. Now you can make it for some other person, you can make it for your own person. So but that person he will be an original design. That has to be an original design if it has to be registered under the IP. Where any person acquires the design or right to apply the design to any article, either exclusively of any other person, means in respect of to an extent in which has been acquired, the person by whom the design or right is so acquired. So basically, if someone is named, say if you're working in a company and if you're doing it for your factory, and so the company can on your behalf apply for the design. In any other case means the author of the design and where the property in or right to apply the design has developed with the original proprietor upon any other person includes the other person in section 2J. So basically anybody who is made it for someone else, those will be called a proprietor. Now, prohibition of registering of certain designs. Now, if it is not a new design or if it's not an original design, you cannot register. Has been disclosed to the public anywhere in India. So basically, you have disclosed it off to the public. You have published it in any other form or any other data. It's already known to people around. It is not significantly distinguished from a known design. So basically, it is a very common design, and people and it's and you can't distinguish it from the other designs. Compresses or contains scandalous or obscene matter. So basically, if it is does not give a good look for the design and it is obscene or scandalous, say if someone approves the design and it can cause friction of public, then also they will not be registering those such certain type of designs. Anybody's got any doubt? No doubt. We'll move ahead. Okay. Now, how does the application of registering of design happen? Now, the controller may, on an application of any person claiming to be the proprietor of the new design, where it's not previously published, can apply to the controller, saying, can file an application form. Every application shall be in the prescribed form and shall be filed in the patent office in the prescribed manner. Now, you might ask why patent office again. In the patent office itself, they have another section which is called the registrar for design. So basically, that will go to that particular department. A design may be registered in not more than one class. In case of doubt to which class a design ought to be registered, the controller may decide the question. Now, a design can be registered in one class only. Now, we've seen there are multiple classes, but here a design can be registered in only one class. Now, if you have a doubt, the controller will decide for you. The controller may, as he thinks fit, refuse to register any design and present to him upon registry, but any person aggrieved by any such refusal may appeal to the High Court. Now, again, as all the other controllers, this controller also has a right to approve or reject any particular design. So if he feels that it is not accepted, he can reject it. Any application which, owing to any default or neglect on the part of the applicant, has not been completed so as to enable registering to be effective within the prescribed time shall be deemed to be abandoned. Now, sometimes what happens is it is incomplete or they haven't given proper information and the controllers ask for information and they don't reply back. That time also it is deemed to be abandoned and it will not be called as a design. A design which, when registered, shall be registered as on the date of application for registering. So whenever you file an application, that's when the the design will be registered. So basically afterwards, whether it's refused, accepted, objected, all of that will happen, but it will be a backdated. Whenever the design is approved, it will be as on the date of registration. Okay, we are done with the one second. For some reason the PPT, whatever PPT I made wasn't saved, so you'll have to go by the textbook now. Okay, so as I said, there is a small workflow also that has been given. Now, an application, numbering and dating of application happens, examination of application. If there's any objection, it's communicated. If there's any non-compliance, then, and if it's not answered, it will be abandoned. If there's no objection, it will be accepted. and notification will be issued in the official journal. Now, if there's no objection, if there's any communication of objection, say someone objected it, again, hearing will be done. Whether it will be refused, high court, and appeal will happen. And if if the hearing is objected and you contested, if they tell remove this particular part of the design or something, if they remove it, then accept it, and it will come in the notification in the official journal. And once it's done, they will issue a certificate. Now that the particular design will be uh, only done in a particular specified class. Now, any questions arising to that class, which the article falls, shall be determined by the controller. Now, he's got a decision to decide on which class the registration will fall in. So that's the bottom of the essential requirements for the registration of the design. Now, what is required when you are registering for the design? The design should be new and original. It should not be previously published or used in any country before the date of applications. Now, again, it needs to be new, and it needs to be originally your design, not copied or used in any other country. The design should elate to feature the shape, configuration, pattern, ornamental applied for or application to the article. So basically, it needs to have some of these configurations. The design should be applied or applicable to any article of any industry process. So if it is a design related to industrial process, it needs to be applied and it needs to be used in that particular industrial process. The features of the design in the finished article should appeal to the and judged solely by the eye. Now, if someone looks at it, they need to explain what they look. The design needs to talk to itself, talk by itself. You do not have to put in any writing saying this is a picture of a hen or this is a picture of a jar. It needs to speak for itself. Any mode of principle or construction of operation for anything which is substance, a mere mechanical device, would not be registrable as a device. So just an end-to-end machine and saying that this is a particular design, that cannot be done. It needs to be a proper method, a proper process has to be followed if you're registering. The design should not include any trademark or property mark or artistic work as defined under copyright law. So you cannot register this as any trademark, property mark, or any copyright. It needs to exclusively registered as a design. Now, as I said, once you are submitting it, they will also publish it in that, so that anybody, it is open to public inspection. Anybody who is having objections can apply to your questions. Now, this is a similar thing for patents and all that. So basically, if anybody objects it, then they will ask the reason for you. They will ask the reason for the person who's objecting it. Then you will have to give an answer for it, and then the controller will decide. Now, certificate of registering. The controller will grant a certificate of registration to the property of the designer when it is registered. Effect of registration of design. The registration of a design confers upon the registered proprietor copyright in the design for a period of registering. Copyright means exclusive right to apply for the design to an article belonging to the class. So basically, it becomes like a copyright where you have the exclusive right to your particular that particular design only. So no one else can use the design other than you. Okay, this is all what we've spoken about. Now, what is the time? The duration for a design, it's 10 years from registration. But where claim to priority has been allowed, the duration is 10 years from the priority date. This initial periods of registration may be extended to a further period of 5 years on an application made to the controller before the expiry of the initial 10 period of years. So in initial claim of priority means if you have already done it before, you are using it, say you're using it, but you haven't uh, announced it to general public, but now after like 5 years you're applying for a registration, then you can do it with effect from previous 5 years. So 5 years plus 5 years plus you will get another 5 years if you are applying it as an initially design. Now, restoration of lapsed designs, Section 12 of the Acts provides that where this design has been ceased to have effect by reason of failure to pay the fees for the extension of copyright, the proprietor of such design or his legal representative um, leave with the controller one or more of them without joining the others within 1 year from date in which design ceased to effect. So basically, if you have not applied, you still have 1 year time to restore the particular design. Uh, if you apply within that particular time, then it can be restored. Now, what can a registration of a design be cancelled? Yes, registration of a design can be cancelled in a prescribed fee to the controller. So the design has been previously registered in India. So basically, it has already been registered. So the new registration will be cancelled. It has been published in India, else prior to the date of registration. The design is not new or original. Design is not registrable. It is not a design under the particular section. So basically, again, if you look at copyrights, trademarks, patents, and all that, they have similar um, kind of points when it comes like can a patent be cancelled or can a patent be revoked, can a copyright be revoked. It's the same thing. So you can just remember points for one particular thing and you can write for all IPs. Okay, there is a concept of privacy of designs. Now, privacy of designs is nothing but you you cannot copy, you cannot replicate the design, you cannot imitate the design and say the design is yours. Like you had piracy of movies. So basically, you're just copying the original one. You're just photocopying the original one, and you're saying that this is the movie. You can go ahead and watch it. Now, similar thing is for a design, design as well. Now, what are the examples of piracy of registered designs is sometimes for the purpose of sale to apply, you kind of make piracy of the particular designs. Say you import any article, you import, say in foreign, the particular design is there, and you import and you kind of sell it as a piracy. That is also not allowed. To publish or expose or cause to be published or exposed for sale. So basically, you want your particular sales to be exposed. So you fake that design and you kind of I'm just giving an example, like an Adidas or a Puma. You kind of fake that design and say that this is a particular design. You can buy it. It's an original product. So that cannot be done in designs. That's called a piracy of designs. It is not allowed. Okay. Appeal here also it is possible. If you are not happy with any decision of the controller, you can go to the High Court within 30 days, within 3 months, and if you're not happy with the controller, you can go to the High Court within 3 months, and the decision of the High Court will be final. So you cannot go to the Supreme Court in the case of designs. So we are done with designs also. Anybody's got any doubts? No, ma'am. So I had written about the question paper nicely, but unfortunately it didn't get saved. Okay. So there is a test paper format which is there. This is for new syllabus only. I am not sure. I cannot give you guarantees that it will be the same format, but this is what is there at the end of your textbook. So you can go through it. It says intellectual property. It says intellectual, economic, commercial, intellectual property laws, Group 2, Paper 6. Now, this format was not there before. This is just one test paper format. I think before the exam format, questions will also come. Sample question papers can also come. So just keep a check on that so that you all know what type of format will be there. Now, whether this particular format is going to come in the exam, I'm not sure. It is there in the textbook, so you can go through based on this. You can expect questions in this particular format. So now you have question 1. This is not applicable for old syllabus because justification and all that was not there in old syllabus. So if anybody is there in the old syllabus, this is not for you. This is exclusively for new syllabus only. So you have part A, which is economic and commercial laws, which is 60 marks. And you have part B, which is intellectual property rights, which is 40 marks. Now, the first question will be justify the same. Now, what happens in justify is they'll give you a question, they'll give you a case, and they'll ask you a question. You need to choose a particular answer from A, B, C, D, and you need to give an explanation on why you chose that particular question. So that's called a justifying the same. So there are 6 questions here, and everything is 2 marks each. So the first question will be for 12 marks. So now 12 marks is distributed among 6 questions. Now you have second question, which is 4 marks each. There are no options here. You have to write all these 3 questions in. So that's again 12 marks. Now in question number 3, you have 3 or 3A. Now both are 2 questions, so it's 6 marks each. So 2, again, that is 12 marks. So you can either write 3A or you can write 3. This is the only place where you will have options. Other questions, you do not have options. Then you have 4 marks each. So again, 12 marks. You have 3 questions. And 5, section 5, again, you have 4 marks each. Again, 12 marks. So basically, the first part of it is divided into 12 marks each question. But for each question, you have coming from 3 different particular chapters. Then you have your intellectual property rights. You have the same justify. You have 4 questions, again 2 marks each. Then you have 7 and 8, which is 4 marks each. 4 questions. There again 16. And the first one is 8. So basically the second one is 40 marks, and the first thing is the 60 mark. Now, if you look at this particular pattern, you will find A will be from a set of chapters. Question number B will be from the next set of chapters. Question number C will be from a second set of chapters. Now, if you look at the particular 8 is copyrights, trademarks, and patents. So they have covered copyright, patents. First one, general geographical indication, designs, that has been covered in point number 7. So basically they distribute various chapters in say 7th section or 8th section. So if you don't know D, or you know only C and B, you don't know A and D, you will still have to attempt, because 4 marks each. So even if you don't know B and C, it's okay. You write A and B at least. So, but one more thing is, don't leave any question unattended. Whatever you know in what question, just write it. Even if you know very little, even if you know 2 points, and if it is for 4 marks and you know only 2 points, go ahead and write those 2 points. It's better to get 1 mark, 2 mark, than get 0 marks. So this is the question paper format that's there. Keep an eye on any sample question papers that come out. Keep an eye on that because this is a new syllabus. You will only know how the question paper is when you sit at the exam. If this format comes, then you all are okay, because you would have already had a sample test paper. when you have studied your entire subject, when you've studied all the chapters, then try to attempt this particular question paper and see how much you can, how many answers you know. Because if you go through it now itself, then you might, after reading everything, if you come back, you'll know the questions. So go through all the questions and then come back to the question paper in the end. So you will know how you are faring. I also wanted to tell for part A, economic and commercial labor's laws. Go ahead and see the previous year's question papers, see what questions have come previously, and try to prepare for that also. Because topics, important topics, I have shared the question paper Excel sheet. So go through that. Whatever questions are repeated will come again here. So say it can come in 3, 4, it can come in 5. So just go through those questions, and at least for part A, you'll have a reference of the previous year's question papers. So just make sure you'll prepare it based on the previous question papers. For part B, everything is new, so you'll just have to go blindly. So yeah, so we are done with the new syllabus.